Hi, everyone. Harry here to talk about a motion the New York DA has filed giving notice of how they would impeach Trump's credibility in the event that he testifies. So let's just start right there. Is Donald Trump going to testify? No, I do not think Donald Trump is going to testify, as anyone who follows this YouTube channel even casually knows. I take that as axiomatic, axiom number one, in fact. However, it's an interesting motion for other reasons. And of course, in the event I'm wrong, it will come into play. All right. In general, two different ways you can impeach a witness. They are very narrow if a witness doesn't testify. You can and we can talk about this separately, but there are certain kinds of bad things they've done in the past that you can raise, not to try to show that they did it before, so they'll do it again, but for very special and narrow reasons. In theory, it's hard to cabin them in front of a jury, but in theory, things like lack of mistake or intent. So, for example, the hush money payment to Karen McDougal here, what was really the catch and kill scheme by the National Enquirer. That's going to come into the case. It's another bad thing that he did, but it's going to come in to show the sort of overall scheme of trying to suppress potentially damaging information about his sexual misconduct to damaging in the sense of his political fortune. So there's a category of bad acts you can bring in if they're going to specific things other than his character. But if he takes the stand, or a defendant takes the stand, puts their credibility at issue. And then a lot of different things can come in if they tend to expose or impeach his credibility. Now, Trump is just, his entire presidency is a unbelievable, limitless smorgasbord of lies and things that impeach his credibility. I'm thinking just of, was the Washington Post who tabulated, in the many thousands, and they could just have their pick if he were to testify of the ones they want to go after. But it's an area in which you have to give notice. So now they've come out and given notice, and they've included the two sexual abuse findings involving E. Jean Carroll, also the defamation, the two defamations of E. Jean Carroll, also the whole civil trial and the finding of fraud in the big case brought by the New York AG, Tish James. So those are, recent in the news and would be hotly contested. And then in addition, and importantly, the DA says any of the things we've asked in category one, like McDougal, or the whole kind of plot with the National Enquirer and David Pecker. If you exclude those, Judge, we're going to want to ask you to let us discuss them if he takes the stand, because they go to credibility. Okay, so in general, you need to show, if someone's impeached, that the thing you're asking them about, if somebody testifies, goes to their credibility. It can be anything. It doesn't have to be a conviction of a crime. It can be you didn't pay your library fines, if that's, but it's just not very probative, but a court can't allow it. But there is another rule that's good to know about that will play out in the trial, which is relevant evidence. And that's what we're talking about when a defendant testifies. Things that go to his or her credibility become relevant, can still be excluded if their tendency for unfair, if they have a tendency for unfair prejudice that substantially outweighs their probative value. And what that legal gobbledygook means is, if it would really be subject to, let's say a good example here where this would be fought out is the sexual abuse, the actual assault of E. Jean Carroll in 1991 in the Bergdorf dressing room. A judge could easily say, I'm not sure that goes to credibility at all, but if it does, it has a real tendency for unfair prejudice in the sense that it makes him out to be a sexual predator, and that's not exactly going to credibility. And even if it is a little bit, that little bit is substantially outweighed by the worry of unfair or undue prejudice. So, damaging evidence and testimony, of course, is prejudicial, but this is undue prejudice. And in the example we're talking about, undue in the sense that the allegations of sexual assault don't really have much to do with the claim that he's dishonest. A little bit, given the way it happens and the like, but it could be that's something a judge could find is substantially outweighed. The risk of prejudice or undue prejudice substantially outweighs probative value. Again, that's a legal mouthful, but it's a good thing to keep in mind because there are going to be evidentiary holdings throughout the case that go on this principle, so-called Rule 403. Okay, so a hearing's going to happen in which they're going to fight over whether these things can come in if Trump testifies. They're going to take the posture all the way to the end that he may testify and he wants to testify, whatever he'll say in the public sphere. And then my prediction is, as in previous instances, he'll fold his tent. Nevertheless, that will make this argument very pertinent, or apparently pertinent, because it'll be, if he does testify, which could really happen. So we want to see how that plays out. We want to see what the judge's thoughts about undue prejudice are and that might matter generally. And this may give some illumination about whether he's going to allow the other kinds of evidence in the prosecution's case in chief, whether or not Trump testifies, things that he has provisionally said are coming in, like, for instance, the testimony of Karen McDougal. So that's the Sandoval hearing, and they'll go through a handful of things they said we want to impeach him over. And the biggest focus, I think, will be the defamation of E. Jean Carroll and the civil trial. And, these are sort of fresh instances that people know about and may, for that reason, pack a bigger punch. Though, as I say, somebody, it's like a kid in a candy store figuring out what lies or even crimes go to credibility that you would use to impeach Donald Trump were he to take the stand, because there's certainly plenty to choose from. All right, but if he does, we'll know after this hearing whether that means that the civil trial would come in, whether E. Jean Carroll, and that, in theory, would affect and that's why you get notice, the decision of a normal defendant whether or not to take the stand. I think we have an abnormal defendant who won't be taking the stand, but the process will be the same and interesting nonetheless. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.